So I think, we'll talk today about joint ventures, which is basically one of the primary practices of any corporate lawyer in India or overseas. What the forms of joint venture that it can take, what is basically understandable, or what is a conceptualization of a joint venture, and what are the main discussion points when we actually negotiate a robust, a resilient joint venture arrangement, document, and an agreement, is what I'll try to cover in the next 15 minutes or so.
So,
Broadly, see, a JV may be defined, there's no strict definition, but it's understood as an arrangement whereby two or more entities cooperate in order to run a business or to achieve a mutually agreeable commercial objective. Now, this cooperation, as I mentioned, can take various forms, such as equity-based JV or a contractual JV. It may be on a long term, it may be on a short term, etc., etc. But it essentially involves the running of a business in perpetuity or on a limited basis, involving the realization achievement of a particular project. Now, let's deal with both types of JVs: equity or a corporate JV and a contractual JV. Contractual JV is basically nothing but two people shaking hands together, saying that, look, I'll get this on the table, you get this on the table, and we'll collaborate with each other, cooperate with each other in order to achieve a mutually desired objective. Now, so typically, in plain classic vanilla terms, an equity JV will be an arrangement whereby a separate legal entity, which is a JV co, is created. See, I'm talking about plain customary things. You can always structure it, customize it, tailor it to suit your objective. But in typical terms, a separate legal entity is created in accordance with the agreement of two or more parties. The parties undertake to provide money or other resources to that particular JV entity or an SPV or contribution of assets, whatever you call it. And this structure is suited to the long term, medium term objects of the project. Now, what is the purpose? Purpose can be two or threefold. It can be others also: to leverage resources, to share the risks by collaboration, to exploit the individual and mutual capabilities and expertise, to increase the market access or reach or outreach, or to expand the business, modernization, diversification, etc. Now, having said that, I think in common terminology, in equity JV, there can be two structures: incorporated or unincorporated. Again, with the passing of LLP Act, we have LLPs also can act as a joint venture vehicle. But typically, we have a SPV, which is a private limited company or a limited liability company, which is incorporated. And two partners or three partners or how many ever partners come together to operationalize that joint venture. Now, what are the forms that it can take? So I think broadly, it can take several forms. One is a plain 50-50 joint venture, wherein both the management as well as the constitution of stake, so management controls and equity controls, are at 50-50 equal. Equal partners, equal platform, everything equal. So, what are the discussion points under that JV agreement? That's one. So, I'll try to cover a couple of them, although they can be various. Second could be wherein I am coming as minority, the other party is coming as majority, both in terms of equity as well as management controls. So, I'm having, say, 26%, and I'm having minority management controls. That party is coming at 74% and having majority management controls. Third situation obviously can be vice versa. When I am coming at 74 or 76%, the other party is coming at 24 or 26 respectively, with majority and minority respectively. The other structured product structures could be, or customized structures could be, wherein I am coming at minority but still have the management control. Alternatively, I'm coming at 50-50, but still have management control. So less equity, but more management control, or more equity, less management control. So let's talk about what can be the broad buckets of discussion. So when we sit across a table, in my experience, I have noticed that the councils, the lawyers of both the parties will come together, and there'll be like six or seven, or maybe eight or nine key discussion points. One is that how the contribution of equity or assets will be done. Secondly, how the management, administration, and governance of the company will be taken care of. Thirdly, if any of the partners has to transfer the shares, how will that be done? And fourth, transfer of shares includes exit also. So if I just want to move out, or the joint venture. Maybe because the mandate has changed, maybe I don't like the other's face, or maybe there's a cause, anything. So exit also is covered under transfer. And fourthly, miscellaneous points, something like, look, non-compete, non-solicitation, IPR, etc. So let's take the example of a 50-50 joint venture. Let's start with the management provisions. So assuming on the board there are total of 6 directors, 3 nominees and designees each, then there are certain matters in which we say that these are critical to the operationalization and business of the joint venture. So both have to consent, otherwise this will not go through. Otherwise, in the board, the decisions are usually taken by majority, simple majority. So if 4 directors vote for a resolution, it will be passed. Under the company's law also, say there are out of 10 matters, 2 have to be decided by the shareholders in a general meeting, 8 have to be decided in a board meeting. But both the matters either take a special majority or a simple majority in board. Board matters, mostly it's simple majority. So the point is there will be contractually agreed some 15-20 items, something like, if you're changing the articles of association, if you are doing a lot of borrowings, if you're in, engaging in a M&A transaction, or if you're doing some major capex, or if you are doing a borrowing or encumbrance, in that case, both the parties have to concur, or both the shareholders nominee or board nominees have to concur. Now, classic case, 6 directors, three each. There's a possibility of a deadlock. So one shareholder wants something, the other person does not. So if he says, okay, fine, the company needs 100 crores extra, why don't we pump in 50 crores each? Now, one party says okay, the other party says no. In that case, a deadlock situation arises. How do we solve that? Because both the parties are equal, both in terms of ownership as well as management. So typically, again, the problem will be like escalated to the top management or the senior management personnel of both the parties. They'll be given like 30 days to resolve the dispute. On a high level, on a top level, to say that iron out the differences and make sure that the objective of the JV is subsumed and subserved, and let's try. But again, there is a possibility that that will not be solved because both the philosophies are different. Then in that case, maybe one possible option could be, you appoint an independent referee who is a person who is known just like an arbitrator, but who will take 30 days or less than 30 days to decide, and his decision will be binding. So assuming the matter is, look, whether I have to enter into this particular transaction or not through the JV, or basically, whether this contract should be executed or not. One party says yes, the other party says no. The top management, again, the difference still subsists. They refer it to a neutral arbiter or referee, whoever, and then he decides. The other could be that why to let the third party decide, the shareholders themselves to be decide. So in that case, we have some unambiguous tiebreaker kind of provisions to say that either a Texan shootout or a Russian roulette or a Swiss auction. Forget the jargon, but essentially means that look, if you don't want to continue because you're creating a deadlock 1, 2, 3 at every step, let me buy you out or you buy me out. So either which way, the parting of hands or the shake of hands will be parted, severed. So in that case, if I give a higher bid, so your shares say, I say, okay, fine, I'll buy you at 100 rupees. You say, no, let me buy you at 101. Then I'll be given a last chance. I'll buy you at 101 or 2, or I'll say, okay, fine, you buy me out. So that is like, Russian roulette or Texan shootout, wherein we just bid against each other and say, okay, fine, I buy you out at each other price. And whoever's price is more, the other party exits accordingly. The other could be a sealed bid window project or process. You bid in a sealed bid, and then somebody has another chance to match the bid or outbid that particular price. So it can be a staggered process, it can be a straight shot process. So that is another thing. So that will definitely solve the deadlock in one way or the other. So that is one discussion point. The second discussion point, which is also very important, is the roles and responsibilities of each of the parties. So one party, assuming, is a financial investor, or into financial services. So it'll say that, look, I have a lot of expertise and experience in asset liability management, asset concentration, treasury, risk management, etc. You are a strategic player. So assuming this joint venture is doing some telecom activity, so you have, the regulator, you have the liaison and coordination, you have the wherewithal and technical know-how, you know how the towers are erected, you know the industry very well, you know the tariff plans. That's it. So you get the technical contribution, I'll get the financial contribution, and we'll call. So this strict demarcation, not very strict, maybe a broad demarcation, delineation, and allocation of roles and responsibility, I think is successful to any joint venture. Till the time we have full visibility, look, that this is what you're going to do and bring on the table. There's absolutely no reason for us to enter into a joint venture. So, which is why the joint venture agreement, one of the discussion point is to actually lay down those responsibilities. But yes, if you lay down, then seeing as a lawyer, what if you don't perform? So either you perform on a reasonable effort basis or a best effort basis, or it's a binding covenant or a obligation or an undertaking. In which case, there are some consequences also built up, which are called events of default. So assuming you're supposed to actually restructure the company and it's your obligation, you're not done that, then what is the default provision? So default can be, look, either you cure the default within 30 days or so, or else, I will have the right to terminate it, or I'll have the right, or the non-defaulting party will have the right to buy the other person out. So basically all these are default or cure of default or consequence of default provisions, whereby I can buy you out at a discount. So obviously, there has to be some disincentive. See, ultimately, Marto, as I understand it, is joint
Mhm.
venture is nothing but an alignment of incentives and disincentives and creation of a risk liability matrix to ensure that the purpose of the business is achieved. Lawyers add value by ensuring that this is the visible, or this is the possible or potential or plausible discussion point. So instead of fighting later, you fight now and resolve it and put it in a documented form. So that's where they add a lot of value. The third would be obviously, as I said earlier, transferability and exit. So if for some reason I want to transfer either a portion of my shares or the entire number of shares, then how do I go about it? So there can be various ways. There can be one, preemptive rights of the other. Preemptive rights meaning that look, before you sell out, give me a right to match that. So assuming I'm a 50-50 joint venture with you, and I want to sell out say 20% of my shares to someone or the entire thing to someone. He's buying me out at 200%. So you will say, look, before offering to him, let me match the offer which that third party has given me. It's like a ROFR. It's like a right of first refusal or a right of first offer, and you will have a first preferential right to buy me out. Hmm? That's one. Second layer is tag along or drag along. In this case, if I find a buyer and that buyer says, look, I want to buy 40%. Now I have 50%, you have 50%. So buyer says, in the company I want to buy 40%. So if you have a tag along right, then you'll say, okay, fine, you sell 20%, I'll sell 20%. Why should you be allowed to sell 40%? It's called a proportionate or a pro rata tag. So that is basically, and the other way around, drag along. So basically, if that other third party says, I have to want 80%. Now I don't own 80% individually. So I'll have to get you also on board. So I'll drag you along with me and say that you sell 40 and I'll sell 40. Assuming, or else if it's not proportionate, then I'll sell 50, you sell 30, something like that. The third could be put and call options. What is put and call option? Put and call option is, look, after 3 years, 4 years, at an agreed valuation, at an agreed time, I will have a right to sell you off. So assuming I'm the financial investor, I don't know the business, but I've invested in the business on your ask. You have come to me for money. I said, okay, fine. I like your face. I like your model. I like everything. I'll pump in 100 crores. But at the end of third year, I will want so much money. If you cannot give me that much money, then either the company goes public, or you find me a buyer, or you buy my shares at a certain valuation because I want my money back. See, I am in the business of giving money, and you are in business of doing business. So in that case, I will have a put on you. Put meaning sell the shares to an individual, identified individual at an agreed price, at an agreed timing. Okay. So these are put and call options. Call is to buy the other out. Put is to sell my shares out. Now it can also create a situation of accelerated put. What does that mean? Look, if assuming in the scenario two, you are in the management, see, there can be a lot of variations to this. So idea is, it can take various forms. It can take various vagaries and variations. But in that case, if a default is there, assuming you are in management control and the business is not performing, obviously it's your fault because you are in control of the company. So I can say that, look, if the business materially underperforms, then I will have a right to put my shares onto you for a premium because you failed to deliver, assuming my returns were linked to EBITDA. EBITDA is basically the performance of the company and a multiple of that. But the business is not performing. So I was supposed to get premium out of the profits of the company, but the company is not making profits because of your underperformance. In that case, after 2 years, if it still subsists and continues, I will have a put on you at a premium of say 20%. So if I have bought the shares at 100, I will sell you at 120 and you will be obligated to buy. So on your part, it's an obligation. On my part, it's a right. So I may or may not exercise the right. So I will have a right, but not an obligation to sell you. But I will have an entitlement option or a right, or which triggers after a certain point of time at a certain price. Second aspect. So this is like preemptive rights, then tag along, drag along, and then put and call options. The second aspect is exit. Assuming the project itself is not taking off. So you thought that look, I will enter into an agreement with you that we'll supply some high speed trains to Indian Railways. So in that case, what happens if the project Indian Railways only says, I don't want because the policy has changed, or just now the monetary policy has come out whereby the RBI has not increased the or decreased the repo rate. It continues to be the same thing. So stock market is come crash. I'm just saying, if there is a third party element, force majeure, or the project itself, the viability goes off, then the party should have right to exit the joint venture. Exit meaning, look, terminate the joint venture for convenience. I don't have to give a reason to you, but I may just, go out. Or for cause also, for good reason also. If there is a reason, then the both parties can come on the table and say, look, this is not working out, let's shake off. Depending on the mutual agreement of parties, you can provide either for one provision or the other or both. For convenience, for cause, or both. For convenience means, I don't have any reason. But I think, for me, I want to sell off this particular financial services division. I just want to continue in the business of banking. So in that case, I will obviously, take out all my investments from that particular thing. So it's my reason, but nothing to do with the joint venture. So in that case, for convenience really helps. If it's for cause, then the other party will say, okay, fine, you are defaulting, but the other party will dispute it. I'm not defaulting. So that is a very practical, realistic issue. So it's always good to have in a 50-50 joint venture for convenience termination provision. Otherwise, when it's 2674 or 4951 or any other joint venture, you can negotiate a for cause and without for convenience provision also. The other usual discussion points are non-compete, non-solicitation. So basically, we are shaking hands with a company, say in France. So France is coming in the power sector with an expertise to say that, I know I have a coal block meaning say 100 megawatt coal block solar generating plant in Andhra Pradesh. But that company, French company, is coming to O&M to do O&M operation maintenance of that. So technology upgradation, maintenance, repairs, furbishing, etc., to that thermal power plant. So in that case, I will say, look, you will not provide such services to anyone else in the country. Or they will say, look, if you have to take these services, you will only obtain from me. So some kind of non-compete, exclusivity, or non-solicitation that I will not poach upon your employees, I will not hire your key managerial personnel, or I will not entice your people. So all these things also come in the 50-50 joint venture as inevitable discussion points. And 50-50, the parties should consider to what extent necessary. One is the space of joint venture, the territory. One is the scope and nature of the exclusivity. And third is obviously the temporal, the time. Until when am I restricted not to engage with someone else? Then what else? Like related party transactions. So if you talk about my company, it has 150 entities. So every entity, so one entity might be in services, one party might be in roads, telecom, oil and gas, energy, etc., etc. So we have cross synergies. So we'll say that while I'm entering into a joint venture with you, I will have some kind of transactions with my own company for the purpose of joint venture, but which will be at arm's length. So basically, look, give me the preference of approaching my own company first, but the pricing will not be discounted or at premium. I will get you the market price. So basically, if the joint venture company needs some IT, information technology platform, so I will go to my own company first. So give me a right of first refusal. If I'm not able to provide you the market rates, then you go to some other company. So, these related party transactions, which are at arm's length, also become a part of joint venture discussions. Then, so we have covered, I think, what? Broad management. See, I haven't really covered the key managerial, but top management, like directors, etc. Then, what happens in a case of deadlock in case of reserved items? Reserved items meaning when both the parties have to consent, only then the item will go forward, which are affirmative veto items, reserved items, whatever you call it. Second, we've also discussed that look, in terms of transferability of shares or exit provisions, what should be the procedure, or what are the usual discussion points. We've also tried to discuss the roles and responsibilities of both the parties. How do you set forth? If you don't do your bit, then what is the consequence thereof? What is the consequence? What are the possible ways, permutations, mechanisms, etc., etc., to deal with that? Fourth, we have also dealt with some kind of miscellaneous discussion points like non-solicit, non-compete, related party transactions, etc., in case of joint. Obviously, if a German party is shaking hands with me, then he'll say, okay, fine, all the disputes should be exclusively referred to the courts of Germany or some other neutral jurisdiction. I will say India. So we'll finally settle on neutral jurisdiction like Singapore or London. So that also becomes a point of discussion. And how should it go to court? Should it go to mediation or reconciliation, or should it go to binding arbitration? So all that, and it totally depends on the project at hand also. And these things become very important when the partnership is not 50-50. If it's 51-49, the whole dynamic, the whole mechanic will change on every point, whether it's management, whether it's reserved items, whether it's transferability, whether it's roles and responsibility, whether it's consequences of breach, whether it's event of default, whether it's transferability of shares, whether it's exit provisions, termination provisions, or tenure provision, and the non and the miscellaneous clauses. So I think, Martha, you'll have to excuse me this time, but at some point of time, I think I want to take a majority minority and minority majority and some structured JVs also, and enter into discussion points in detail when I have some more time, maybe this weekend or so. But they become very, very critical. In a simple, plain vanilla structure, everything seems rosy. You shake hands. When you don't like each other, shake off. But here, when the idea is 51-49, then things become tricky. And how do you lawyers deal with that, or how should they deal with that, is what I will probably take up in the subsequent lecture.